Welcome back to this next part of the law and ethics lecture for this week in week 2, all about contempt of court. I told you there was a lot that we had to get through, so forgive me if I do seem to be going on, but we need to make sure we've covered this really important subject. And as I mentioned, this is the subject of your essay for this module in this trimester. So it's important we cover a lot of bases. So where have we got up to? So that's where we were. We've looked at the basic, the legislation involved, contempt of court, 1981. We've looked at that basic definition of strict liability contempt of publishing material, which causes a substantial risk of serious prejudice or impediment to active proceedings. We've looked at what makes up when proceedings become active, when they cease to be active. We looked at what happens during appeals. We've talked about the fade factor and how that can offer us some protection. Then we've been through the defences, the Section 3, Section 4 and Section 5 defences. Then we've looked at the automatic reporting restrictions and the court orders that can exist. And so it's quite a lot of stuff to remember in this about how do we report safely when it comes to court proceedings. I want to move on now to protecting sources. It's an important subject for us as journalists. It's your professional code, our professional code, that we protect our sources. The moment we betray our sources and reveal a source to somebody, that undermines all journalists and all journalism. It may sound like an overdramatic thing to say, but it really is your duty to protect your sources so that people can talk to a journalist and feel confident that they will be protected. But what if a court orders a journalist to reveal a source? Creates a very difficult situation because it would be a contempt to disobey, and I'm saying you must obey the law. But Clause 14 of the Editor's Code, remember the IPSO code, it says it's a moral obligation to protect confidential sources of information. And of course, there is a wider moral obligation that somebody could be at risk if they became known as the person who had given information. The Ofcom code, the Ofcom broadcasting code, also says in section 7.7 that we should guarantee that contributors should be given confidentiality or anonymity. And that should normally be honoured, says Ofcom. So basically both of our regulators, IPSO and Ofcom, are saying that we should protect our sources, but law is saying that we should not disobey a court order. We also have protection under Article 10 of the European Convention of Human Rights, freedom of expression, so we can argue that. And there is a slight protection offered under the Contempt of Court Act 1981. Now it's known as the Section 10 defence. So it's not one of the main defences, but it's known as the Shield Law, Section 10 or the Shield Law. And what that says is that no court may require a person to disclose, nor is any person guilty of contempt of court for refusing to disclose a source of information contained in a publication for which he is responsible. And that's fine up until there. So it's saying, okay, you can protect your sources. Unfortunately, the sentence continues. It says, unless it be established to the satisfaction of the court that disclosure is necessary in the interest of justice or national security or for the prevention of disorder or crime. So basically, if a judge tells you or decides that it is necessary for you to reveal a source, you don't have the protection of Section 10. So in spite of the fact that we've got Section 10, we've got the Editor's Code from IPSO, we've got the Ofcom Broadcasting Code, and we've got the European Convention of Human Rights, ultimately, Contempt of Court Act says it's up to a judge whether we should reveal a source or not. So that's very difficult because I'm absolutely telling you that you should never reveal a source, which can mean that it places you in a very difficult situation. There are a whole series of cases at the bottom of the screen there where you'll see that things like the Shield Law have not worked, and that courts have put pressure on publications and journalists to reveal sources, and to some extent they've been successful. They have forced journalists to reveal their sources. This is my experience of it. So I was on the Manchester Evening News when we revealed the identity of the person who planted a bomb in Manchester, the IRA terrorist who planted a bomb in Manchester. And our crime reporter, Steve Panter, who used to be a lecturer with us as well, he discovered the identity of the person who the police believed was the bomber. We published that, and even though nobody had ever been arrested from the IRA for planting that bomb, Steve was arrested. And when the police launched an investigation to find out how Steve knew, they charged one of their own officers as being the source of the information. Steve was called to court, and the judge ordered him to reveal his source, to say whether the officer who was charged was the source, and Steve refused. And that was a very difficult situation to be in, because the judge was ordering Steve to reveal his source, so it was a contempt to say no. But on the other hand, we've got all of those other things. We've got the Shield Law, we've got the European Convention of Human Rights, and we've got the IPSO and Ofcom codes telling us that it's our professional duty not to reveal our sources. Steve, rightly in my mind, refused to reveal the source, and in the end the judge backed down and didn't prosecute him for contempt, but he had some very, very uncomfortable few weeks where he was told that the judge may well take that action. So protecting sources is absolutely key. I wanted to say another word about juries. Remember I said last week that you have to be very, very careful, and I said that you should treat them as untouchable. There is the Juries Act 1974, which says that it's a contempt to obtain, seek, solicit or disclose or publish any details basically of what they did, of their discussions in the jury room. So there is a law which tells you that you must not publish any certain details about what juries discuss. So those details will include any statements that they've made, any opinions that they express about the case, any arguments that were expressed in the jury room, or any votes cast. You can't report any of those things. Otherwise, if you do report any of those things about what any of those jurors either said, any of their opinions, any of the arguments, or any of the votes that they made, you're in contempt of court. So you have to be very, very careful. That's why I was really stressing last week, and I'd repeat again, be very careful around jurors about saying anything that they might say or do during the deliberations. Inquest gets similar protection. Won't go into that just now. Don't want to distract you too much. But yeah, jurors, be very, very careful. Also want to talk about other contempt risks. So audio recorders. The Contempt of Court Act 1981 in Section 9 says that you mustn't take an audio recorder into court. So don't do it. You can't broadcast any recordings. Pictures, similarly, slightly different law, but again, just wrap it up in the things you must not do around court. So the Criminal Justice Act actually says you must not take any photo or film in court or in the precincts of the court, or not even do a drawing in court. So you remember that case I mentioned at the beginning with the BBC getting into trouble because they used a recording of a Zoom, effectively a Zoom case, or a case being heard on Zoom. The journalist recorded it that way. This is the law that they broke, so they ended up in trouble because of this. There are some exceptions coming in. Don't be lured into thinking we're going to end up like America, where court cases are televised. But there are some sentencings. There are some experiments going on where there are some new rules being tried out where sentencing hearings can be broadcast, but the camera has to stay on the judge. So don't worry about that just yet. You'll know if you're allowed to do it, because there'll be a big hoo-ha around it. At the moment, no cameras, no audio recorders, no drawings in court. Similarly, if a jury is taken to a visit, quite often, for instance, a murder case, the jury will be taken on a bus to see the scene of the crime, so they can get more of a sense of what happened. When the jury's at the scene, you must not take any pictures of the jury actually at the scene. It's as though the court has come with them. So just be very careful of all of that. Right, we've got through all of those things. Just a few concluding comments then. So make sure you structure your thoughts. Think about legislation, think about definitions, and think about defences. With every subject that we talk about, think about that. So let's have a think today. So legislation, Contempt of Court Act 1981. Key definition involved in this is the strict liability rule. So your intent is irrelevant under the strict liability rule. And the definition is that it's publishing material which creates a substantial risk of serious prejudice or impediment to active proceedings. So that's the really important definition. You must commit that one to memory. And then defences, remember we had section 3, so I can see them run out of screen here. We had section 3, which is not knowing proceedings were active, but you have to show that you're taking every reasonable precaution. We have section 4, which is a fair and accurate and contemporaneous report of court proceedings published in good faith. And then we have section 5, a discussion of public affairs. So those are the key defences. So, excuse me, I'm about to sneeze, which is why I'm looking a bit funny. I think I'll do it. A reminder about the essay, finally. So I gave you the essay question last week in the workshops, and it's a 1,000 word essay, plus or minus 10%, so 900 to 1,100 words. And the question was, I asked you to explain the impact the law of contempt has on the work of a journalist in England and Wales. So I need you to give a basic description of the law of contempt in England and Wales. So with that, I'll expect you to define it and give the definition that it's publishing material with that creates a substantial risk of serious prejudice or impediment to active proceedings, and I'll expect you to say what active proceedings are. You'll then also describe the key defences that are available. So remember, we've been through those key defences, section 3, 4 and 5. Then I want you to illustrate your answer with a recent example of a contempt case heard in the British court. So I expect you to go and find a recent example of that. There's some guidance also. If you look on Blackboard, there's with the essay question, there's some guidance. So I actually give you a plan. That bit up the top there under guidance is a plan. So stick to that plan. It tells you, give me an introduction, name the legislation, explain how it's applied, set out the main defences, use a relevant case study, and end with a conclusion that explains the overall impact of the law of contempt on the work of a journalist. And there's a couple of little reminders at the bottom there about making sure you focus on on the law in England and Wales. Don't just Google stuff and start talking in your essay about things that happen in America. Irrelevant, not interested. It has to be about the law in England and Wales. So keep an eye on all of those things. And reading for this week and next week. So for this week on contempt, if you haven't done it already, please read chapters 12 and 19 of McNay's Essential Law for Journalists, the 25th edition, remember. Have a look on Blackboard. I've put lots of materials on Blackboard as well to help support your understanding of contempt. So lots and lots of examples. So you see loads of case studies on there. I'm hoping you'll go and find your own case study for your essay. And then for next week, you're going to be with Sarah Hadwin, and you're going to be talking about defamation and starting 2 weeks on defamation. It's a really important subject. So for that, to prepare for next week, would you read McNay's chapters 20 to 25? So all of those chapters, 20 to 25. So it's a nice big section, but it's an interesting subject, defamation, and probably one of the most important areas for us as journalists. So make sure you've done that reading by next week. And then other than that, I will see you at the workshop on Thursday. Remember to turn up to your workshop, the correct workshop that's on your timetable. I'll see you there on Thursday, and we'll run through some sample exam questions, typical exam questions to do with contempt. So thank you for your attention, and see you on Thursday.